Good afternoon, members. Welcome to the policy briefing by video conferencing for the panel on administration of justice and legal services. Is the appointed time, and we now have a quorum. Through the Zoom video conferencing platform, we will be briefed on the 2021 policy address policies by the Secretary for Justice and Director of Administration. I will introduce the officials today. With us today are Ms. Teresa Chang, SC Secretary for Justice, Ms. Christina Chang, Law Officer, Civil Law, Ms. Linda Lam, Law Officer, International Law, Ms. Maggie Yang, Director of Public Prosecutions, Mr. Michael Lam, Law Draftsman, Ms. Gracie Fu, Director of Administration and Development, Mr. Llewellyn Mui, Solicitor General Acting, and Dr. James Ding, Commissioner of Inclusive Dispute Avoidance and Resolution Office. We also have representatives from the Administration Wing of the Chief Secretary for Administration's Office. We have Mr. Daniel Chang, Director of Administration, Ms. Eva Yam, Deputy Director, and from the Judiciary Administration, Ms. Esther Leung, Judiciary Administrator, Ms. Wendy Chang, Deputy Judiciary Administrator, Ms. Winky So, Deputy Judiciary Administrator, Mr. Dominic Chow, Acting Deputy Judiciary Administrator, and from the Legal Aid Department, Mr. Thomas Kwong, Director of Legal Aid. Welcome. I remind members that you must activate the video function in the Zoom system and show your faces. Your microphones would only be switched on upon my instruction. During the meeting, if members wish to submit any papers, please send them to the email account of the panel. To allow members to speak in an orderly and fair manner, our colleagues would first clear the raise hand markers in the Zoom system, and members who wish to speak, please press the raise hand function. I would invite them to speak in turn. All LegCo members have been invited to this item. We now enter the agenda proper. Number 1, briefing by the Secretary for Justice and the Director of Administration on the Chief Executive's 2021 policy address. I would first invite Ms. Teresa Chang, SC Secretary for Justice, to brief members on the paper. After that, I would invite Mr. Daniel Chang, Director of Administration, to speak before we open up for questions. Secretary for Justice, please. Thank you. Chairman, members, this is the first policy briefing of the panel on administration of justice and legal services. Myself and my colleagues at the Department of Justice look forward to an earnest cooperation with members in the coming year. On the new policy initiatives from the 2021 policy address, the DOJ briefed members last October. Members of the 6th LegCo, and details are listed in the paper we shared with the panel earlier. Today, I would highlight salient points on the progress of these latest measures, and hopefully we can have more exchanges going forward. The 14th Five-Year Plan of the nation supports the development of Hong Kong into an international legal and dispute resolution services center in Asia Pacific, and many initiatives of the DOJ have achieved good progress in recent months. In order to implement the arrangement on reciprocal recognition and enforcement of judgments in civil and commercial matters signed in January 2019, the DOJ is now drafting a bill, and public consultation on the legislative proposal was completed in January. 14 submissions were received, generally supporting the arrangement. The arrangement made reference to the draft of the Hague Judgments Convention and expanded its applicability under the unique benefit of one country suit systems to cover judgments made on contracts and infringement disputes, making Hong Kong the only jurisdiction to establish such a such a wide scope of mutual recognition and enforcement of judgments. The DOJ would strive to introduce the relevant bill to LegCo in the second quarter of this year. In December last year, the Law Reform Commission of Hong Kong published a report on outcome-related fee structures for arbitration, recommending a reform on legal fees on arbitration. The relevant proposal was expressly supported by the Advisory Committee on Promotion of Arbitration. We are now drafting the relevant amendments to implement the proposal so that Hong Kong's arbitration services could be kept up to date and that more people would choose Hong Kong's arbitration and legal services. At the meeting on the 28th of this month, the DOJ would consult members of these two bills, and we hope members would support the bills. The Greater Bay Area Legal Professional Examination, the first batch of candidates who passed the examination are now receiving intensive training online provided by the Guangdong Lawyers Association. After the training and upon passing the online interview assessment, they can apply to practice in 9 mainland municipalities upon application to the Department of Justice of the Guangdong Province, and the second exam will take place in June this year. The third Greater Bay Area Legal Departments Joint Conference held in December last year endorsed the GBA Mediator Accreditation Standards and GBA Mediator Code of Conduct Best Practice. And the Sale of Goods United Nations Convention Ordinance was passed at LegCo in September last year. We have started work on promoting the CISG, or United Nations Convention on Contracts for the International Sale on Goods. We held seminars with the Hong Kong General Chamber of Commerce, the Asian Academy of International Law, etc. Upon completing the relevant procedures under Article 153 of the Basic Law, and after the Central People's Government makes the requisite notification to the Secretary General on the United Nations on applying CISG to Hong Kong, the CISG can be expected to be applicable to Hong Kong by the third quarter this year. One of the initiatives under the 2021 policy address is to develop Hong Kong into an international legal and dispute resolution services center in Asia Pacific, including the holding of important meetings in Hong Kong. With the support of the Central People's Government, the 59th annual session of the ALCO will be held, has been held for the first time at the Hong Kong SAR. Meanwhile, the United Nations CITRAL also held the first working meeting in Hong Kong. It was the first time the working group held its session in Hong Kong. As for the AALCO, they announced the setting up of the Hong Kong Regional Arbitration Center in Hong Kong, and it shows the support from AALCO to arbitration services in Hong Kong. As Mr. Li Keqiang, the Premier, said in the annual session, the setting up of the Hong Kong Arbitration Center will provide more efficient and effective dispute resolution services for Asian and African nations and add vibrancy to Hong Kong, which is the Pearl of the Orient. Meanwhile, at the Hong Kong Legal Week held last November, the DOJ activated the Rule of Law database, which would collate objective data and researches related to the implementation of rule of law. In terms of rule of law education locally, the DOJ will continue to pursue the 3E projects, including activities for primary and secondary school students and teachers to provide teaching materials on the Constitution, basic law, national security, etc. And this year marks the 25th anniversary of the reunification to the motherland, the DOJ will organize multiple activities, such as the international or basic law summit, as well as the Hong Kong National Security Law Summit, and through the insights offered by experts, public awareness and understanding of the Constitution and national security could be enhanced, and this is conducive to the successful implementation of the basic law in one country, two systems. We hope members would support the policy measures we just outlined, and we are happy to take questions from members. Thank you very much. I now invite Mr. Daniel Chang to walk us through the paper. Thank you very much. I would talk about the latest progress of the initiatives of the judiciary and the area of legal aid. The judiciary has been using technology to enhance the efficiency of court operations, and where appropriate, remote hearing would be adopted. But due to the current legal obstacles, remote hearings could not be used extensively in criminal proceedings. The judiciary is drafting the relevant legislation to allow judges and judicial officers to conduct remote hearings as appropriate. Before tabling the legislation in LegCo, relevant stakeholders would be consulted. Meanwhile, the judiciary is also working on procedural reforms on this family justice system. The objective is to make the justice system more convenient and efficient. In the middle of this month, the judiciary would first consult the public, and later this year, the judiciary will brief the panel on the outcome of the consultation and the proposed bill. And in terms of court facilities, a lot of work has been completed in recent times, including the expansion of the defendants' booths at Wan Chai Law Courts building, while a mega courtroom at the West Kowloon Law Courts building has been expanded. Some members from the previous term of LegCo made a visit already. Meanwhile, for Tsuen Wan Law Courts building, it was recommissioned in October last year. Since the judiciary has to deal with a large number of cases, especially cases arising from opposition to the proposed legislative amendments in 2019, the government has offered substantial support. 4 courtrooms and relevant facilities have been accommodated at Wan Chai Tower. Progress is satisfactory, and it is poised for completion in mid-2023. In terms of ongoing initiatives, the previous LegCo passed a legislative amendment on September 30th last year to adjust the legal aid fees. It was 2.7% for civil or criminal legal aid fees, and it took effect on the 8th of October last year. At the previous term of LegCo, we also briefed members on the outcome of the review on legal aid. This is to prevent potential abuse, increase transparency, and enhance public understanding of the work of the legal aid department. These enhancement measures have been implemented by the end of 2021. Chairman, that's all for my report. We are happy to answer questions from members. Thank you.
Thank you. And now, questions by members. Now, we have these members right now. In that order: Lam Fan Kang, Chairman Kee, Kwong Yuk Poon, Priscilla Leung, and Priscilla Yong. Please, if press the button if you wish to speak. Now, there are not that many members speaking, so you have ample time. Mr. Lam first. I have two questions, one for the Secretary for Justice and the other for Administration. Shall I ask them separately? You can ask both questions. First, for the DOJ. Now, from the DOJ report, including the report on the latest progress, I fully commend the DOJ and the Secretary for Justice for promoting legal education, mutual assistance with regard to the mainland, and the work for promoting Hong Kong as an arbitration center. This panel will monitor and study the related matters, including the progress by officials. So we have the duty to monitor and study how to enhance the skills of law in Hong Kong, and so that the community is well served. In this regard, I feel that the DOJ has not done well in recent sessions. So I strongly request that the DOJ set up a committee to study along with the Law Society and Bar Association on ways to enhance the skills of the legal professionals so as to meet Hong Kong's needs, such as the bond market, green finance, asset management, trust business, maritime and aviation matters, and so on. Perhaps we will let the Secretary respond first. I thank Mr. Lam for his reminders. Now, all along, we have been working with the Law Society and Bar Association and other legal professional bodies to provide more training opportunities. Now, we try to work along the lines proposed by the bodies concerned. We can enhance our communications. Now, one of the things that the DOJ can do is that for private practitioners and also those in public service, we can try to obtain more service opportunities for them in international bodies such as that in Hague, so that the professionals can enhance their exposure, and we also try to enhance the competitiveness of professionals in the GBA. So we have the second law professional examination for the GBA soon. Now I will ask the other members to speak now, and then you can continue asking the SJ in your second round. Now, concerning the policy address, first, now the legal practitioners can be authorized to practice in both mainland and Hong Kong. Now, is the DOJ going to provide more information on practice in the GBA? Will you set up an information center here in Hong Kong, or set up a hotline so that solicitors and barristers can obtain the information? And also, concerning recruitment and training of talents. Now, under one country, two systems, and government by patriots. Now, of course, apart from the DOJ, there is also outsourcing. Now, will some of the training practice, training focus on legal thinking and Xi Jinping thoughts, more on the theory side. And these are these would be public service jobs. So Hong Kong is executive-led. Now we have independence of the judiciary in certain aspects. Now on software side, now practitioners have told me that they want to take forward e-submission and so on first. And on the hardware side, some courts will be expanded or redeveloped. Now for the legal sector, now there are some magistrate courts where the cells are inadequate because there are more defendants, and also there is a larger body of audience, so the ventilation is inadequate, and also ventilation is very poor in the cells. Now these involve public health, so the secretary, please pay heed to that. And on the overall allocation of space, have you allowed space for the unrepresented cases, especially in family matters, for consultation purpose? Now the legal aid department has to allocate the cases in a fair manner. Now, whether it's solicitors or barristers, looking at the data, quite a number of the practitioners are qualified, but they haven't received any assignments. Now, is it drawing of lot system? Now, how do you assign the cases fairly to the panel solicitors? And also, the legal aid department should also open the cases to young barristers or those with less seniority. Now, the criminal cases from the magistrates' courts and so on can be assigned to more junior solicitors. Now, I declare that I am a panel solicitor of the legal aid department and I'm also a member of related organizations and official of those organizations. Now, first, the Secretary for Justice, please respond. I thank Ms. Chan for her question. Now, some of the questions involve my work, so I will respond on those parts first. Now, you mentioned the market information for the GBA. Now, we can consider what you propose, but it may not be very easy to achieve because we have to work with the mainland. So we work through the GBA Joint Conference, Legal Departments Joint Conference. Now, after the pandemic, we will try to provide some matching. Now, Hong Kong practitioners through the GBA Legal Professional examination can work with law firms on the mainland. Now, also on training within the DOJ, especially on matters related to the national developments. Now, we have done 3 times this year already. Now, there are basic courses with 9 units on basic law, national security law, law system in of our nation, and other developments within the country itself. So it's a very good course. Now, the courses should be taken at least once during the first 3 years of probation. Now, the Civil Servants Academy will also have a similar requirement, as I understand it. Now, this course responds to what Ms. Chen asked about. Now, we also provide other training. For instance, we arrange for them to go to international organizations such as the Hague Conference, UNIDRA, and UNCITRAL. Now, some private lawyers cannot go to the latter, but they can go to Hague Conference and UNIDRA. And also, we send DOJ lawyers to Asian Development Bank for training. And within the DOJ, we have a professional exchanges program. This allows private law firms to have members engage in the DOJ work. So they will help us to enhance our arbitration work, and some of our colleagues who engage in litigation more also practice in barrister firms, barristers establishments. So this is two-way, so the government lawyers can understand more developments in the market. Now, we also have on-the-job training. A lot of our colleagues have accumulated a lot of experience. They share that experience with more junior colleagues, and this is ongoing, so that the body of knowledge can be enhanced. We will also invite external speakers to provide training. For instance, university academics speak on investment law, and also we invite the WTO. Also provide send some personnel to provide training in relation to WTO. And now on whether practitioners have to affirm allegiance to the country. Now, this is being taken up by the government. Now, I think this will soon be decided by the government. Now, whether it's according to Article 6 of the National Security Law or under the Constitution of Government by Patriots, we know that this has to be pursued. But the relevant policy bureaus will come up with policy initiatives, and we will provide our opinions. Now, on the courts and legal aid, I will only supplement one point. Ms. Chan asked whether more can be done in some matters. Now, we are participating in personal injury cases where we make use of e-filing. So other colleagues, I believe, would supplement. Ms. Chan's question also involves the matters relating to judiciary and legal aid. So perhaps I will let some other members ask their questions first. Ms. Kong? First, I thank the DOJ for starting many initiatives in the past few years, taking forward the legal sector. So I appreciate the DOJ's work. Now, first on the rule of law education. Now you have taken forward such education in both primary and secondary schools. Now, I have also participated on the pilot scheme for such education. Now, I went to some secondary schools. If we take that first to the secondary schools, now it's a bit too late. Now, I know you have also introduced such education in the primary schools. I think you should strengthen such education in primary schools. And also on education on the rule of law, now the teachers play a major role. Now the learning by the teachers is also very important. Perhaps the DOJ can work with the Education Bureau on providing more training to teachers on the rule of law. Now, also on public education, you should enhance the education of rule of law. In the past few years, now the public has maybe had inadequate exposure to such concepts.
Secretary, you talked about the Law Reform Commission in the paper. You will be reviewing the statute law. I'd like to know when you will review certain pieces of statute law. What are your criteria? Can you give us a concrete timeline or any specific goals in the coming years? Secretary, for important judgments, a gist is provided. I have visited your website. So resources and manpower permitting, would this be extended to other case laws, such as case laws related to livelihood issues, for instance, in areas like building management, contract management, disputes, etc. So would the arrangement be extended to such civil matters? I looked at the practice of the DOJ in Singapore. They work with university law schools to come up with case briefs. So for a law student, this is excellent training. And this could help the DOJ as well. Finally, in terms of mediation, the training of mediators is currently conducted by different organizations, and the cost is rather high. It costs about $20,000 for the training and examination. So in terms of training up mediators, could the DOJ provide funding or centralized training courses? Secretary, please address these 4 questions. I'd like to thank Ms. Kong for her questions and views in terms of rule of law education. You were right in that working with secondaries alone is not enough. For primary schools, like we discussed, there are drama performances and quiz competitions, so we will continue to work with primary schools. And we would extend our work to kindergartens as well by creating simple pamphlets we can educate children on the concept of law-abidingness and rule of law. For teachers, we work with the Endeavor Education Center. The Education Bureau and the school head associations also invited us to deliver talks, and I personally have delivered 2 such talks, so hopefully our work can continue. We also work with associations that have contact with young teachers, and through these associations we hope to promote certain concepts in terms of public education. We want to do more as well. If not for COVID, we would have conducted a lot of community initiatives already. So far we conducted the Studio DOJ initiative involving animations, but due to COVID, we were unable to directly engage the community. So hopefully, once the pandemic is over, we can resume our work. As for our work with the Law Reform Commission, like I discussed in the report, apart from looking at new issues, there are 3 areas of work we want to work with. First, the adaptation of our legislation, wording such as Crown, Majesty, etc. would be amended as soon as possible. So the LRC Secretariat have commenced the work. We are also involving relevant policy bureaus, and we will brief LegCo at an appropriate juncture. We will come up with an approximate timeline soon, and by then we can share that with members. Another area of work of the LRC is to remove outdated provisions, and this is also important since some outdated provisions no longer apply to Hong Kong and should be removed. The LRC would also seek to consolidate certain laws. Some of the laws are scattered here and there, so we would have to consolidate these laws, and that might be rather time consuming. So our priority is on adaptation of legislation. Then we will delete obsolete or outdated provisions, and finally we would consolidate the laws by working with relevant bureaus. The DOJ compiled gists of the case laws. You offered a very good idea. We compiled briefs for cases that involve the DOJ. For other case laws or civil case laws, compiling a gist might be helpful for other members of the public. Currently, our civil division does prepare briefs for civil and commercial cases. So thank you for your suggestion. In terms of mediation, this is something we would have to look at. I understand that cost is one issue. We will consider the issue and offer a response. Thank you very much. Dr. Priscilla. Dr. Priscilla. I'd like to thank the chairman and the secretary for justice for briefing us on their work in the past year or the coming year. A lot of issues are outstanding, and I see work has started, including rule of law education in the community. I appreciate the effort. Some of our members used to run community junior lawyer courses. Many children enjoy the role play, and they developed an interest in becoming a lawyer when they grow up. Last year, the DOJ recommended some talents for secondment at international organizations. It was a great idea that would be helpful in attracting the right talent to the DOJ or government. So I really appreciate the effort. Now I have a few questions. First, for court proceedings in Hong Kong, we greatly lack efficiency. We work with the courts, and the Court of Final Appeal, we understand that efficiency is lacking, and some people are really anxious. And in terms of work upfront, such as the consolidation and submission of documents, is efficiency lacking as well, because I have great concerns because justice delayed is justice denied. For cases of great social significance, we would send a very confusing signal. From 2014 to 19, many of the cases were yet to be closed. Even cases from 2014 were yet to complete. And that is why some people were still trying to put the law to the test. We have always been saying that court proceedings in Hong Kong are way too slow. We talk about procedural justice, but there were cases in which cases were yet to reach the CFA in 6 or 7 years. For important cases, very often you would brief out the cases to fiat counsel. So the more significant the cases, the final judgment might involve significant public interest. For counsel in private practice, they might be an expert in their own fields, but they might not necessarily consider the social impacts. If their relationship with the DOJ is merely that of a client, but the DOJ has a social or public role to play. So when briefing out the cases, you must be very careful. So we discussed the out-briefing system in recent years. So can the Secretary for Justice tell us her view or stance on the system? So it's not just about money, it's about public interest as well. Dr. Lang, please pause here. You already spent almost 5 minutes. Secretary.
好多謝梁議。
Thank you very much for the questions. I'd like to clarify some of the misconceptions in our community. Chairman, when we look at the efficiency of processing a case, Hong Kong has certain mandatory legal proceedings or procedures in terms of submission of documents after a charge is laid. After one or two steps, the case could be taken to the court, and the laws in Hong Kong allow the defense to make certain applications or request a postponement of the trial. So the problem is not just down to lack of efficiency in submitting documents. Very often the formation would take place twice, but long delays because of DOJ are not common, because prolonged postponements would require an explanation. And in terms of the paperwork or documents, we need to understand that translation is sometimes needed, and after they are translated, well, some reports accuse us of lacking efficiency in translation, because after translation is completed, we need to go through certification, and certification takes time and it is beyond our control. So after translation, we have to go through certification before the work is completed. Then we can commit the case. So this is something I'd like to make straight. Of course, we hope to achieve better efficiency, and we are doing our best.
I
will cite an example. Looking at the period 2019, because we mentioned the 2019 cases, the riots outside Polytechnic University, the police arrested 230 people in 19th of November, and then very soon the defendants were taken to court, and then very soon we provided the written reports were provided, and now the cases are due to be heard. The first one March this year, and last one later in 2023. So it does take time, and on 19th of September 2019, 90 people were arrested, and then in October 19th, the DOJ already provided opinion, and then 90 people were prosecuted, and then in March 2021, the reports were provided, and then the cases are due to be heard in September 2023. So there are a lot of things that have to be arranged. That's just one example. As for outsourcing, when we do outsourcing, we have regard to the performance of the lawyers concerned. So we look not just at the cases themselves. The department concerned will provide to us the performance reports on the performance of the lawyers concerned. If there is a problem, we will not engage the lawyer again, because we have a duty to ensure fair and efficient judgments. Ms. Yong, now I have several questions regarding the policy address. Vision 2030 focus on rule of law. I noted that the theme website has been commissioned. How is it operating? Because I saw only one page by the SJ on resolving legal disputes, but there is lack of other contents. Now, the composition for the task force is not provided, and the roadmap is not provided. So when will you provide more content? And on the database on rule of law, what data will be in that database, and then some people outside Hong Kong try to smear Hong Kong on the democratic process in Hong Kong. Now, the task force on the focus on the rule of law, will they speak on our behalf on the rule of law? And what is the purpose or duty or functions of the task force? Because experts come from Nigeria, Japan, and other parts of the world. So how do they operate, and how long do they, how frequently do they meet, and how under what circumstances will they submit reports? And then on rule of law education. Now, given the pandemic, most schools do not hold regular classes. So will you provide the information online? And now you dealt with national security law forums and basic law forums, and then you broadcast that on the internet. Now, will you include such material for secondary school and primary school students and to the teachers concerned? And we have also been told that there is a lack of teaching materials in English. So for the minorities, there is a lack of resources for translation. So will there be more teaching materials in English? Now, on mediation, that has been my concern in the past. So can we have more mediation in the community? And I am also concerned about the mediation center in West Kowloon. I've submitted a written inquiry. So what is the current progress there? We thank the member for her question. Now, the Vision 2030 focus on rule of law. The website is continually updated. Now, we are at incipient stage, so we have to do more work to enrich the contents. Now, as for the database, now we provide objective data that have existed all along. They are not data only available to certain government departments. They are available to the public all along. So if you look at that website, you see that we have certain basic rule of law elements, and we express that through data. Now, the work is not fully developed yet. The task force provides us with visionary ideas on how to implement that. The DOJ will be tasked to do that work, but we will also might engage experts on how to improve the communications. Now, we hope that the Vision 2030 task force can provide a report in the first half of this year, so that we know the next what to do next. This is a 10-year project, so the first couple of years may not be very rapid in progress. Now, for those who try to smear our rule of law, we should have the data, objective data, to rebut such arguments, and also to review our own work. Now, on the rule of law materials. Now you will note that in the document submitted to you, we mentioned that we have provided online education resources along with the Basic Law Fund. Now there have been 12 online seminars, 400 teachers participated, a large number of visitations, and we have received good feedback from the teachers. Now on the legal forum, now the audience is the legal professional sector, those who are more educated. So the legal forum, such as the Basic Law 30th Anniversary Forum, we have some proceedings which are helpful to both lawyers and teachers. So after every conference, we hope to publish some proceedings that will become teaching materials. Now, concerning the basic law, this year we will provide annotations as a basic education material for the basic law. So this can be in the form of a book. Now, as for the materials being provided in English, this can be resolved. We can provide that to some schools if they are needed. On the West Kowloon Mediation Center, the DOJ and the judiciary continue to support the initiative. We employ a pilot scheme. Now, we have the support of the Advisory Committee on Mediation, and we are working closely with the judiciary on its continued operation, future operation. Now, this will take us through the middle of this year. Now, and then on the future, afterwards, we will be exploring that with the judiciary, and they will come up with the results soon. Holden Chow, Cameraman, and Paul Chair, who they have not yet asked their questions. And for the second round, Lam Ban Kang, Ms. Chan, and Dr. Priscilla Leung. For others who wish to speak, please press the button or raise your hand. Otherwise, we have to draw the line. Holden Chow, please. Do you hear me? Yes. Happy New Year to you all. My main question is to follow up on what we mentioned previously, the Vision 2030 focus on rule of law. Now, we have stressed that we should provide our students with a substantial program for education on rule of law. Now, the SJ has taken on our comments now on introducing a dedicated post for that. Now, on how to start the schemes concerned, you have taken on board our suggestions, and I think that is right. Now, given the pandemic, now Now the audio is not totally available now. Now the pandemic is not under control yet. Now, if classes are to resume in video mode, now how will you handle the education on rule of law? And then the second question, now just now members asked about what's said in the policy address on the DOJ personnel on occasions where there are allegations that are untrue from abroad on the rebuttals there too. Now, when you have a plan against that, now can you tell us more about how you will speak out more against that? I know there has been greater effort in this regard. Now, you have spoken out more frequently and provided more rebutting comments. But perhaps you can speak in person more frequently. Thank you, Ms. Secretary. Now, there were some audio signal problems. Do you have a full grasp of Mr. Charles' questions? Now, I will try to respond. Now, in the rule of law, Vision 2030, now on how we work with the schools, we try to keep exploring the way forward. Now, what can we do given the pandemic? Now, our drama program, we try to provide that to the primary schools, but due to the pandemic, they have to do that on the internet.
繼續去做。咁我哋至於其他嗰啲工作啦。
As for the other areas of work, they are under review. One example is the rule of law education pilot scheme for secondary school students. It was conducted for a year, and we are looking to extend it because 1 year was certainly not enough, and hopefully we can continue to refine rule of law education. As for expanding the scope of the scheme, that would very much depend on the Education Bureau, and we would do the best of our abilities. I have heard your comments, but it is not just about the government. If there are wrong accusations from the legal sector towards the government, apart from, well, whenever there are these wrongful accusations, I think the whole legal sector should speak out. Ms. Lillian Khan.
多謝主席。
Thank you. I'm happy to see the Secretary for Justice, her team, the Chief Secretary's office, as well as Judiciary Administration, to brief members and take in our views. On different occasions, the Secretary for Justice has said that Hong Kong is the only common law jurisdiction in our nation, and judicial independence and rule of law are the cornerstones of our success. The Secretary also talked about the extradition law saga in 2019, and On different occasions, the Secretary for Justice has said that the enactment of the Hong Kong national security law has restored order to Hong Kong. And in the news release in October last year, the Secretary said that when scrutinizing national security related cases, judges have been impartial and independent and not due to any interference. I'd like to stress that Hong Kong must continue to embrace judicial independence. I see that Ms. Esther Leung, Judiciary Administrator, is here, so I have a question about the national security law. One of the main roles of the Judiciary Administrator is to provide support to judges. As for the training for appointed judges for national security law, are there concrete plans? The Secretary held the National Security Law Legal Forum last year, and it was made clear that the NPC Standing Committee was the only was the body who has the final interpretation of the national security law. So it's important to correctly understand the provisions in the Hong Kong national security law. As for the training for appointed judges is of paramount importance. Would Ms. Leung or Ms. Chang answer this question? Who would take this question? Judiciary Administrator. Thank you. Thank you very much for the question. As the Chief Justice of the Court of Final Appeal said in the opening ceremonies of the recent legal years, there's an emphasis placed on the training of judges. Since 2021, the Judiciary Academy under the JA initiated a series of judicial training programs with the mainland, and these are not limited to specified judges for the national security law. Since April last year, we have hosted a series of seminars, and in April, under the themes of Hong Kong national security law and the Constitution, thematic seminars were held. The last seminar was held in October, explaining the role of the NPC Standing Committee and the judiciary development of the mainland. Speakers included our judges, and the deputy of the Supreme People's Court was also invited. Participants included judges under the judiciary, legal practitioners, representatives from the DOJ, and the two legal professional bodies. This year, we will continue to hold these thematic talks. Once the pandemic eases, we have plans to arrange visits to the mainland by judicial officers to enhance their understanding. Anything to add? Ms. Chang? I have nothing to add. Thank you. Next, Mr. Poche. Good afternoon. Am I coming through? Yes. Good afternoon. In terms of the study on remote hearings, in order to enable remote hearings, LegCo amended the rules of procedure and carried out relevant work. The judiciary has conducted over 1,000 remote hearings since April 2020. For civil hearings, progress is relatively slow. I'd like to know what obstacles were encountered. What is the bottleneck? Is it that difficult to amend the legislation given the experience at LegCo? I'd like to know the actual situation and how we can speed up progress of the relevant work. Some members talked about the long waits for civil cases or proceedings. I understand that certain proceedings or procedures take time. According to the relevant report, about 80% of the criminal cases were completed at district court level. Progress is very slow. There are 230 outstanding cases. We understand that a lot of defendants are involved. There is a lot of evidence and many documents must be translated, and documents must be converted into text from video. So how can we be fairer to defendants? Many defendants have been kept in custody. For those involved in less serious cases, their ultimate sentence might be shorter than the time they have been held in custody. Apart from enhancing efficiency, for cases not of a serious nature, can they be referred to magistracies that would be more efficient? Is there anything that could be done to streamline the system? I know that justice must be upheld, but we all know that justice delayed could be justice denied. So we want to know what the actual obstacles are. Having to wait 3 or 4 years is certainly not ideal. So a response from the Judiciary Administration and DOJ are needed. Secretary, I would address the second question. For criminal cases, judges who decide to conduct a trial would not cater for any lawyers, and the defendant cannot postpone the case since a certain lawyer is not available. Judges have very packed schedules, and this is something we must acknowledge. In some cases, we saw that a single incident could be tried as 3 separate cases. So could they be dealt with as a single case? At the DOJ, we hope the cases would not be so scattered. If incidents could be dealt with as a single case, then it will be more efficient. As for national security law related cases, well, for any case, we are looking to boost efficiency, but we must also consider the due process. Article 42(1) of the National Security Law points out that cases must be processed in a timely manner, and this is not just about the prosecution. Both the judiciary must also deal with the cases efficiently. So when scheduling the trials, this is something that would be taken into account. We are constantly considering how we can speed up the processing of cases. V-bargain might not be the best approach since we need to consider the preferences of the defendant. You asked about the courts that process the cases. I think this is part of the decision of the prosecution. We must consider the relevant cases and criminal liability, and the court that is most fit. So we need to strike a careful balance. As for the question about remote hearings, Ms. Leung. For civil hearings, since April 2020, we have enabled the dealing of civil hearings by remote hearing. So with the COVID-19 situation, different levels of court have allowed civil remote hearings. For criminal hearings, a number of legal issues must be dealt with. In our first round of consultation, the Bar Association raised a series of questions about principle. So in terms of legal drafting, we are reaching the final stage. The two legal professional bodies would look at the detailed provisions in the second round, especially the circumstances under which remote hearing can be conducted for criminal cases.
Because in criminal cases, the justice has to be implemented in an open manner, and there's a certain threshold to be met. Now, within this year, we hope to complete the second round of consultation, so the bill could be submitted to LegCo for scrutiny. I will draw the line here. Now, in the first round, Mr. Yim Kwong. Happy New Year. I come from the business sector 3. We are I'm one of the few members who are not from the legal sector. Now, the business sector is very concerned about the rule of law. Now, I am here to learn. That's my mentality. Now, I support the proposal for enhancing education of rule of law in schools, and then in the 14th National 5-Year Plan, now support is provided to Hong Kong, for Hong Kong to become a dispute resolution center, arbitration and dispute resolution center. So that is an objective. So the GBA disputes can be dealt with in Hong Kong. But the litigation cost in Hong Kong is very high. For my company in the past 2 years, there was a simple case and tens of millions of legal costs were involved. Now, if legal disputes are to be placed in Hong Kong for resolution, how will we reduce the cost? I thank the member for his question, because litigation costs are very deterring for many. Now, just now, the member mentioned arbitration costs. We are competitive there, but if we want to enhance our competitiveness, we may have to carry out some reforms. So we try to work through amendment of legislation so that the arbitration cost structure proposed by the Law Reform Commission, we hope that to be implemented through legislation, and so that there can be more flexibility in how the fees are levied, so that the business people and so that the parties to the case can be subject to a more reasonable fee structure. Mr. Lam Van Kang, second round. Thank you, Chairman. Now, in the Secretary for Administration's document, it said that the judiciary has all along adopted technology to enhance efficiency. Given the COVID-19 pandemic situation, the judiciary since April 2020 has engaged in over 2,000 remote hearings. I'll share with you my experience. In 2020, now, in 20 years ago, I visited Singapore. They already used a e-filing system. Now, and then 20 years later, I went to Dubai, and then at that time, the parties concerned can see all the documents on the internet. And then I also visited the mainland. Now, the digitization in the administration of justice in the mainland is really eye-opening. Now, we have started last year the e-filing system that other people have used 20 years ago. And you claim to have dedicated yourselves to the raising of efficiency. Would you like the SJ or the Secretary for Administration to respond? Perhaps the Judiciary Administrator, Ms. Leung. We thank the member for his question on enhancing efficiency through technology. We admit that we want to digitize and modernize a lot of our procedures, but we have to be cautious in the implementation. We are moving full speed. In the beginning of this year, we are developing a case management system that covers all levels of cost. This is the e-filing that Mr. Lam mentioned in March. Now, in district court cases, we will deal with court documents electronically. That will include payments. And then in the summons courts, that will be implemented. And then in the second stage, it will apply to high court and small claims tribunal and so on. So in the first 5 years, the costs will be reduced with a 20% discount. So there will be resources provided to the courts. Now, why have we been rather slow? Because there are a lot of legal amendments involved. As of the end of last year, the subsidiary legislation and in the district court and so on, the amendments have been completed. And this year, we will start with the implementation. So we are trying to improve the situation. Now, we will try to provide all the assistance we can in the legislation process, but I hope the digitization should be taken forward full speed. I'll extend the meeting by 15 minutes because there are two other members to speak. Mr. Chen, Ms. Chen, would you like to repeat your question? Now, firstly, is the question for the Central Administration on software and hardware in courts. Now I agree Mr. Lam's points on backwardness of our system. I hope that the technology can be implemented ASAP. Now, at least we should improve our rule of law and the business operations environment relative to the mainland. Now, this will benefit the public and the business sector. Now I'd like to speak on hardware. Now there are many litigants and many cases, and then there's the pandemic. Now many lawyers complain that the ventilation is very poor in magistracies and courts of first instance and so on, and there is no air purification system at all. Now, can you upgrade the system? I think it can be purchased very quickly. How about legal aid department? Can I ask that question? Now, I'd just like to make the point that in legal aid department, there should be more participation by younger solicitors and barristers. Now, perhaps the criminal cases can be structured so that the MAC court cases can be assigned to the younger lawyers in that manner. Now, qualified solicitors and barristers, on what criteria are they chosen? Now, there is a lack of transparency, and on the form, now there should be updating. Now, many say that you should take over 16 cases for 3 years. Is that a firm requirement? And are the cases allocated fairly? I'd like the DOJ to to speak first. As mentioned in the document, to cope with the volume of work in the courts, and since more and more defendants are involved, now we have tried to make the best use of our courts. If we can increase the capacity, we've tried to do that. The speaker is Ms. Leung. Now, in Wan Chai, the largest court is now expanded to cope with 50 defendants. Now, there's a similar initiative in the Chin Wan Court, and this year in Wan Chai, there will be one court which will accommodate more than 50 defendants. So there will be more space for the participants, our attendants, and to alleviate the congestion in the court. Now, on poor ventilation, we have been monitoring the situation. If necessary, we will introduce amendments. Now, during the pandemic, at the courts, we try to regulate the flow of persons so that there can be better social distancing to improve the ventilation. In the new court buildings, we will pay more heed to these issues. And then legal aid department, please. Now, at the end of last year, we have established a roster. Now, this is based on information from the panel lawyers, their work experience. Now, at the end of the year, we implemented new measures. Now, for instance, I give you a figure. Last month in January, now that includes cases implemented since the end of last year. 202 cases are allocated by a roster to qualified solicitors and barristers. Sorry, is this criminal or civil? This is criminal cases. Now, we start with district court cases because those are more simple, not so complex. The more complex cases and high court cases are assigned by the EA Legal Aid Department. We have regard to the roster, and we also take into account the complexities of individual cases. Now, in November last year, there was no roster. So for qualified panel lawyers, I think they will notice the improvement. We will further examine to see whether there is scope for expanding.
We must realize that for the legal aid department, the welfare of the beneficiaries is of utmost importance. And we would always consider the interests of the applicants. So we would consider whether further expansion is possible. Thank you. Finally, Dr. Priscilla Leung speaking for the second time. Dr. Leung, are you here? Am I coming through? Yes. We are happy to see a breakthrough in the legal aid system, and the Director of Legal Aid also addressed that. And we hope we can finally see an improvement. To follow up on the previous question, we hope that DOJ is aware that for 35 plus cases, some have been scheduled for 2023 or 24. These are cases of public interest. The public has a lot of doubts why there is such a long wait. We believe legislation for Article 23 of the Basic Law will take place this year. So does the DOJ have enough manpower? I talked about briefing out cases. I think where possible, most cases should be dealt with by the DOJ's in-house lawyers. And that is why I want to know about your recruitment progress. I've been on the committee on bilingual legal glossaries. I think the bilingual glossary is not very well compiled, so many lawyers still prefer English. So in terms of achieving consistency in trilingualism, so there have been inconsistencies that should be tidied up. In terms of recruitment, can we minimize the use of briefing out counsel and barristers or counsel? We are not talking about counsel in criminal matters, but you have been engaging the same few counsel all the time. I respect their professional expertise, but apparently you are always asking the same lawyers. You would not reach out to other lawyers. At the end of the day, I believe the DOJ has an important role to play in terms of public interest. So we should strive to train up in-house lawyers while attracting new blood. That is how you create this ladder that would really reassure the public. So in terms of legislation for Article 23, there will be an increased workload. And did you look to attract quality talent to the DOJ and facilitate internal promotion? So the question is whether you have enough talent. Of course, the more talent, the better. We have a very heavy workload, especially on Article 23 legislation. We have a dedicated team, but having said that, the workload is certainly heavy. And we would do our best to our abilities. Every year, we see a lot of applications, and many of them would be accepted. But we cannot lower our requirements just to recruit more people, because we want more capable people. We do not want any incapable staff. That is why we have set certain requirements. In terms of promotion, I can say frankly that I certainly encourage my colleagues to make appearances on court by rolling up their sleeves, and this includes criminal and civil cases. We created a team to offer training in techniques involving civil proceedings. Last year, we talked about amendment to the Legal Practitioners Ordinance, that is to allow government counsel to become SC. So for counsel and senior counsel, very often they have to take up different work all the same. So I encourage my officers to take on the cases themselves, but in some cases we would have to engage fiat counsel, and that would be done. You said you are looking at the same fiat counsel all the time. So sometimes I would ask my colleagues about the reasons for engaging the same fiat counsel. So we would not habitually engage certain counsel, but certain cases are complicated, and one or two fiat counsel are experts, so we have little choice but to engage them. So that's my response. That's all for the questions and answers. Dr. Junius Ho, our time's up, so if you wish to speak, please make it quick. Thank you very much. I would not repeat what other members said. The Secretary just addressed Dr. Priscilla Leung's question. I think it's a good idea to do it yourself, and that's certainly a positive attitude. In the solicitor and counsel sectors, how can we encourage more solicitors to become solicitor advocates? The scheme has been implemented for almost 10 years. Currently, only about 110 solicitors took part in the solicitor advocate scheme. I think this should be promoted, and that would be done by the Law Society. Can we lower the threshold as well? A barrister pupil can engage in limited practice after half a year. For lawyers who have practiced for 30 years or so, we have to submit evidence, and we need to have filing evidence. I think such bureaucracy would hamper our progression, so that should be avoided. For practice skill courses for mainland lawyers after they pass the exam, and they could practice after receiving training. For PSDAS, I think that's a good idea. Many lawyers in Hong Kong have passed the GBA legal examination. If we restart the PSDAS by injecting $20 or $200 million to support the legal and other professions, that would be good news for sure. Secretary, anything in response? I would not address the second point. The first point was about solicitor advocates. Hong Kong's solicitors and barristers have a self-governing system in terms of the adversarial principle. The submissions of the lawyers on court are significant to the judge, and that is why there are strict requirements. When I used to engage in international arbitration, we saw that many lawyers had great advocacy skills, even though they were not barristers. So I think this is something we can learn from. Thank you very much. That's all for the questions and answer session. Item number 2, any other business? Barring any other business, the meeting's adjourned. I thank members and officials for attending the meeting. Thank you.